Hello there, and welcome to this webinar, during which we will discuss price increases and delays. My name is Melissa Adler, and I'm the Executive Director for Industrial Relations and Legal Services with HIA. Members have been letting us know that COVID-19 is causing delays in the supply of building materials from both local and overseas sources across the country. Combined with the unexpected increase in uptake of the Home Builder Grant, there is now significant pressure on the availability of labour, and price increases are emerging across the building supply chain. While the extent of these delays and cost increases will vary in each state, HA is aware that this is leading to cost pressures and is impacting the timely progress of many building projects. During this webinar, we will consider some of the commonly asked questions about how to manage price increases and delays during residential building work. One commonly asked question we get is, can I pass on price increases to products and materials to our clients? In most cases, the answer is no, but it does depend on the type of contract you are using and any specific clauses that might be in that contract. If, for example, you are using a fixed price contract, then the builder is responsible for any costs above the fixed price, except for those costs that might be incurred because of a variation that's requested by the client, or that are due to matters outside the control of the builder, such as a fire, a war, strikes, or natural disasters. If you are using a cost-plus contract, however, the client agrees to take on any changes in prices. The client is charged for the actual cost of construction plus profit, which is normally expressed as a percentage of the costs of construction. Depending on your state, there may be some restrictions on using cost-plus contracts. We also get asked about provisional sums and prime costs and whether or not price increases can be passed through these items. Provisional sum or prime cost items for specific trades may provide some protection against cost increases. Prime cost items are a fixture or fitting that has not been selected, or the price of which is not known when the contract is entered into. Under the contract, the builder must provide a reasonable allowance for these items. However, the end price may change depending on the item's final cost. This might include, for example, the supply and installation of tiles when the homeowner has not made a final selection about which tiles to use. This price can be adjusted accordingly and no variation to the contract is needed. Provisional sum items are an estimate of the cost of providing particular contracted services that the builder cannot state a definitive amount for when the contract is entered into. This might include, for example, excavation work. In both cases, these items and a reasonable estimate of their costs should be identified in the contract, which also sets out how to make adjustments to these amounts if needed. But what if continuing to work under a fixed price contract becomes unprofitable? Well, even if the effects of COVID-19 and government stimulus are pushing prices up, it is unlikely that a court would intervene and help out a builder to increase their price. Future material price increases should have been contemplated when the contract was quoted. Just as an owner is not able to reduce the amount paid if the price of materials decreases, a builder is not entitled to pass cost increases on to the owner. So if you have entered into a fixed price contract, there are very limited ways you can increase the costs of labour and materials to pass them on to your client. You may have heard a lot about rise and fall clauses or cost escalation clauses. So what are they? Well, a cost escalation clause is a provision that allows the contract price to increase to reflect increases in costs of labour and material, or cost increases due to delays in carrying out the work. A rise and fall clause is a provision that allows the builder to pass on to the client increases and reductions in the cost of performing work. Generally, changes in the price of labour, materials, or any other specified factors can be adjusted and passed on to the homeowner according to an agreed formula. despite there being a fixed price under the contract. This can lead to the homeowner also paying a lower price. The next question we often get is, does my HIA contract include a rise and fall or cost escalation clause? Unfortunately, HIA contracts do not include rise and fall or cost escalation clauses. This is for two reasons. Firstly, in some places across the country, these types of provisions are banned and will either be considered void or unlawful if included in a residential or domestic building contract. Where these provisions are allowed, they are complex to draft and administer and can result in the builder being worse off, and is another reason why they are not included in our HIA contracts. Now, how do variations work in relation to any price increases? Can you use a variation to pass them on? You may be able to pass on a price increase through a variation in two circumstances. The first is if there has been an omission, addition, or change to the building work, or a change in the manner of carrying out the building work. This may be suitable where a product or material is being substituted, and this results in a price increase. So how can you respond to price increases during construction work? Well, it depends. If you're using a fixed price contract, unless there is a contractual provision which allows you to, you cannot pass on a price increase. Under a cost plus contract, you can pass on price increases as you are charging the client for the actual cost incurred at the time you incur it. We also get asked whether HIA will draft a rise and fall or cost escalation clause. Unfortunately, HIA will not draft rise and fall or cost escalation clauses. However, we are happy to discuss the pros and cons of having these types of clauses in your building contracts. Now, moving on to delays during construction work, can you ask for more time to complete the building work? The answer is yes. While HIA contracts deal with this slightly differently across the country, generally, if something happens during construction work that causes a delay that was caused by something outside of the builder's control, and was not reasonably foreseeable at the time you entered into the contract, you can ask for an extension of time to complete the work. Now we'll just go through two examples of situations where extensions of time may or may not be appropriate. The first one relates to a situation where a building contract was signed in September last year and work commenced in February this year. Then the builder was told that they wouldn't be able to get timber for at least 2 months. What should the builder do? Considering the impact of COVID-19, announcements regarding home builder, and the significant take-up of the grant, it was unlikely that in September last year you would have known that these factors could have impacted on the supply of materials and therefore the time taken to complete the building work. In these circumstances, it is reasonable for you to claim an extension of time. In another example, where a building contract was signed in January this year and building work commenced at the beginning of March, it became apparent that the builder was having trouble securing trades to ensure the work continued smoothly. So what should the builder do in that case? Well, from the beginning of this year, product, material and labour delays and shortages were becoming apparent. So from January, builders really needed to start factoring in these delays to the building period. While this might make it difficult to claim an extension of time, it is always worth discussing this with your client and asking for more time. What if the client is unhappy about allowing extra time to complete the building work? Well, in some states, you do actually need your client to agree to an extension of time. In others, you might not. However, in both cases, there are 4 things that you should do during the construction project. The first is to monitor the progress of construction work and track it against contracted timeframes. Secondly, you need to talk to your client and communicate any delays or disruptions as soon as possible. Next, you could provide evidence to support your claim for more time. For example, economic information or correspondence from suppliers may help convince a client that the delay was not foreseeable at the time of signing the building contract. And finally, and as a last resort, you can use the dispute resolution clause in your contract. So where can you go for further information? HIA has developed a toolkit for members and their clients to help manage delays and price increases during a residential building project. Members should also contact a HIA workplace advisor for further advice and assistance. We hope this has been useful information and we wish you the best of luck. Thank you.